So you start.
Ready?
Who, me?
Good afternoon. It's me, Sandra. We at Maryland Crime Victims Resource Center. Joining me today is Alonzo Robertson. He is one of our attorneys. And we are taking you today for our Facebook Live into the courtroom. So you'll have to be very patient with us, as we are not videographers or cinematographers. We just wanted to make sure that you guys know what to expect when you're in the courtroom. So we're starting out here in the lobby. All your lobbies are going to be different, so this is just going to be the bare basics as to different components that you can expect. All right, so I'm going to give you guys Alonzo.
All right. Well, good afternoon. Glad that you joined us for our lunch. First place we're going to start off with, as I give you an overview of the courtroom, is the attorney conference room. It is usually outside of the actual courtroom, and it is allowed for victims and their attorney to come and sit down a little bit before the case, sometimes during the case, to work out issues in private. So as a victim, you may find that your victim advocate, did they want to pan into the room? Yeah. Everyone in the room, of course, is a little different, but this is how it's situated. All right. It gives you and your attorney an opportunity to sit down, work through some issues. Occasionally, we actually have the family sit inside there when the testimony has been a little rough and they need to be away, but they don't want to miss the rest of the court proceedings. So follow me, we're gonna go ahead into the courtroom. We're in Calvert County, all right? Thank you. Thanks to State's Attorney Bob Harvey. And this is the entrance of the courtroom. In our particular case, it's courtroom 4. I'll hold the door for you. Okay.
Coming into the courtroom here. Oh, you know what? Let me flip this. No, it's fine.
All right. Every courtroom is going to be a little different. However, the components of the courtroom are primarily the same. When you first enter into the courtroom, you're going to come into the area for the observers. In the back here, where we have some of our staff working, the observers who are just public citizens who want to see what's happening at the trial can come in and sit down. Under American law, most trials, some family law trials are restricted, but most trials are open to the public, and so you're able to sit in any one that you would like to. You will also find, however, that there will be 2 rows in the front, right before this bar. These rows are reserved for the attorneys for other cases that haven't been heard as of yet, and for the police department or law enforcement officers who will sit in the front, and they will be able to move in and out of the court as they need to. So this area, we call this area number 1, is more for the observers. Everybody has heard about the bar and the well that's inside here. This separates the observers from the judicial system in its operation. And you're not, as a victim, you will not go past this area unless you are a witness. But only the attorneys and the witnesses will go into this area. At this moment, before we actually go into the well, I want to point out some of the people who are serving that you will run into while you're in the courtroom. So the first one will be our judge. And the judge will be usually at a higher table all the way to the back of the courtroom, or from your perspective, all the way to the front of the courtroom. And our next person that you will see is the clerk. The judge's clerk takes care of identifying the cases that are going to be heard, getting any paperwork that needs to be done, printed out, and then assisting the judge in finding things while that judge is on the stand. We're going to jump now to one of the persons that you may end up serving as, and that is the witness. The witness's table is usually on the, in between the prosecutor and defense table and that of the clerk's table. And this case is here on the left-hand side of the courtroom, and our witnesses there would be sworn in by the clerk and then be required to go ahead and give their testimony. Now, some of the additionally important people that you will find in the, I can say that to the judge, but the other important people that you will find is our defense attorney, who is there to make sure that the prosecutor has shown all the evidence necessary to prove his case, and our prosecuting attorney, in this case, our state's attorney himself. Okay, thank you very much. The last place that I'm going to point to, and I'll be that individual, is the jury box. Here is where the citizens who have registered for voting or have a driver's license, they are selected randomly to provide a review of the facts that have been presented. While the judge is going to address the laws, the jury is going to look and see if they believe what the witness has said is credible or not. All right, so now we've gotten an overview of the courtroom. Some of our actors will need to leave, so I'm going to start in the back and talk about a few things, and then we'll see what we can do next. Let's see. All right.
So again, I want to thank Bob Harvey.
Yeah.
He's our state's attorney, and he's also on our board. He's the state's attorney for Calvert. He set up so that we could use this beautiful courtroom to give you guys information. And then they are currently in the process of course. But hopefully we will catch them again during our Q&A.
Okay. All right, and actually, now that you mentioned, because Bob has got to leave, why don't we take a moment? Bob, tell us a little bit about what the prosecutor does and what role you have in this whole court proceeding.
Well, first of all, the state's attorney, there's a state's attorney in each county and the city of Baltimore. They're elected officials. Got me?
Yeah.
Each state's attorney has a staff of assistant state's attorneys. Each office, some are big, some are small. Here we have in our county 15 lawyers who assist me in prosecuting cases.
Okay.
Our job is to present the evidence on behalf of the state of Maryland, citizens of the state. When someone is charged with a crime, we review the charges. We determine whether or not there's probable cause to move forward with the case. And if there is, we're responsible for going into court and presenting the evidence through witness testimony or through physical exhibits. Sometimes there are expert witnesses involved, doctors, psychiatrists, whatever it is. Our job is to present the evidence on behalf of the state. But we also have a higher responsibility, and that is to make sure that we do justice. We have an ethical obligation. It's right in the Maryland rules. We're required to do justice. Justice extends, however, not only to the criminal defendant, but also to victims and witnesses. And we make sure that our victims and witnesses are kept informed what's going on with their case. They're notified of all important court dates and, of course, allowed to attend. And at the end of the day, they're allowed, if there is a conviction obtained, allowed to present victim impact testimony to the judge as to the effect the case has had on them and their family and what they would like to see happen ultimately. So that's what we do.
Thank you very much.
Every single day.
Every single day. Well, we appreciate that. And I thank you for that. You also have served on the defense side as well. So did you want to talk about that, or we have it? Would you like to give us a brief overview of what the defense does as well?
As it's not unusual with a number of prosecutors to kind of jump from one side to the other. And from my perspective, that gives you as a prosecutor a little bit better perspective on the workings of the criminal justice system. So yes, I was a defense attorney. I started out as a prosecutor in Prince George's County for many, many years. And then I went out in private practice where you can earn a little bit of money. And your job is to represent persons who are charged with crimes. And you make sure that the prosecution does their job, that the evidence that's submitted is properly admitted. You make all the appropriate objections. make sure that everyone's following the law and that your client, the defendant, gets a fair and just trial.
Thank you very
Thank
much.
you.
Now, I know you have to run,
I
so
do.
I'm going to let you
Well,
get on
thank
out.
you very much.
Thank you guys for
Appreciate it.
having
Good to
us.
see you.
Oh, our witness is leaving too. Okay. All right. Well, that's great. Now we've seen what the prosecutor does. We have an idea of what the defense does. Now I'm going to give you a little bit of perspective about what the victim's attorney does. My role and I'm a victim attorney, and my role is to ensure that the interests that Bob talked about a moment ago, are protected for the victim. I do not argue whether the homicide took place or any of the evidence. That's what the prosecutor does. But you have a right as a victim to be present, to be heard. And I make sure that it was a viable hearing. It's not just that they heard you yelling down the hallway that I don't agree with the activity. They actually are taking your information and your interest into consideration. That's why I stepped out here. I generally do not sit inside the well because my focus is my client who is out here in the observation area. So I sit with my victim to make certain that they understand what's happening, that if they have a concern, I can get up and get the attention of the prosecutor, but I'm not allowed to go into the well in some courts. And that's a very big qualifier. Every court, we have 23 jurisdictions in Maryland, and we have a circuit court and a district court. In some counties, we have 2 district courts. Every court has a different layout, and the judges for each of those courtrooms runs that courtroom. And so that judge may say that the prosecutor can pull up another seat and let the victim's attorney sit with them. And on those occasions I have, and in other occasions I have opted to stay with the victim. Now we have a question online. Let me hear what that question is.
How involved is the state's attorney with each case? And is the state's attorney the primary decision maker in how cases proceed or are tried?
Okay, that's a very good question. Cell phone view? My camera's over there. Sorry, folks. All right. The question is, how involved is the state's attorney on the decisions and the litigation that is taking place? We can sit down. We sit down. So
My camera's getting super heavy, guys. I'm just saying.
all right. So the first thing to think about is that the state's attorney has a number of attorneys that work under him or her. And that state's attorney is the kind of the administrator for all the cases that are occurring under his or her jurisdiction. However, the individual attorneys have the legal responsibility, they have the ethical responsibility to maintain understanding of the court and figure out what the elements are. There is a rule under attorney law that talks about a supervising attorney. So if I'm a new attorney and I think I should go in a particular direction, and my supervising attorney, the individual who is ultimately responsible for the actions of the office, believes that it should go in a different manner, then I have an opportunity to look for another job or to take the advice of my supervising attorney and move in that direction. Very often it doesn't come to that, but on occasion it does, where the determination of the attorney who is working the case may significantly differ with his supervising attorney. However, a supervising attorney is a supervising attorney or a state's attorney for a particular reason, and that is that they have a vast amount of experience. And despite what we sometimes see on TV where the new attorney comes out and dazzles the world, there is very little new under the sun. And so a supervising attorney or a state's attorney advice and guidance can be significantly helpful to you. Is there another question that we have?
Do you find that the state's attorney will actually contact the victim's family directly or the victim directly, or do they just work within the system?
Okay. again, there's a generalization that I don't want to make too broadly. Well, I can't make too broadly, and that is every state's attorney may handle things differently. The state's attorney, however, the likelihood of a state's attorney getting in contact with a family doing a trial outside of the courtroom, it may not be something that we would normally see. It will be the attorney and their operations for the most part. Now, we have had cases, high-profile cases, where the state's attorney, instead of having one of his or her senior attorneys take the case, that state's attorney will actually take the case as well. So, and that happens. But because they're in charge of, in this case, he has 15 attorneys, and in other counties there are upwards of 100 attorneys. The time that is relegated to being on any one case for a person who's in charge of the other 100 cases that are taking place is kind of minimal. In fact, if you think about a district court attorney may have 40 cases on a particular day, jumping from one place to another. All right. So let's we don't have a question online. Let me just run back on one thing. Okay. All right. We were talking about the witness area. We walked in, and there's a question. When you come in, you don't know where to sit. Do you sit on the right-hand side or do you sit on the left-hand side? And the reality of the matter is that it doesn't matter. You can sit anywhere that you want to. Generally, however, the victim's family and the person that is prosecuting the case, the one that is the victim, and their witnesses will sit on the same side as the state's attorney. So how do you know where the state's attorney is going to sit? Well, we talked a little bit earlier, and I said, here goes the state's attorney's desk. Over here was the defense desk. In many courtrooms, the state's attorney's desk will be on the side closest to the jury. Not all, but on many times, that's the way it's going to be. Also, because the attorneys sometimes don't know which side to sit on, there'll be a little placard that says, I'm the prosecutor, and over there will be the defense. So you just look and see where the prosecutor's table is or where the jury is. And if there's a side of the courtroom that will allow you to sit, that's the side that you sit on. All right. So we've stepped within the well. We're in here where only the officers of the court and people who are being sworn in are allowed to be. As a victim, you will not be able to come inside this area unless you are a victim/witness. Even when you give your victim impact statement, you will stand outside the well so that the sound can be projected from there. Again, don't want to oversimplify, but some judges will allow you to come to the witness stand or to stand with the prosecutor. This is a very small courtroom, so the likelihood of that being the case is not very high. You'll probably stand at the well. But be flexible, understand that what you're getting here today is a generalization. Every courtroom is different. I've been in courtrooms where there's 4 benches for the witnesses, the attorneys, the police, and everybody else in totality, where there is no jury box at all, where the clerk's desk is a little desk on the side of the judge's desk. And then I've been in places that are elaborate like this, and even more so, where it's an opportunity for you to see. Talk to your attorney before you go in, or the victim advocate. They will assist you in understanding what's happening and understanding what you're experiencing. Now, let me go to where we've entered the well. Inside the well, we talked about the prosecutor, we talked about the defense. You will also find your sheriff or your law enforcement officer and the bailiff. Those are the 2 sets of people, a law enforcement officer and a bailiff. The law enforcement may stand over here where our colleague is standing in one of those 2 seats. Their job is to maintain generally the safety of the defendant and the people who are coming into the well. Now, that's different than the responsibility of the bailiff. The bailiff, who may be seated here, let me step forward. Bailiff may sit here, and that person is, that's the reason there is because they are going to move from the attorney's desk to the clerk to the judge when they're handing over evidence or they're handing over documents that the judge needs to look at. So the bailiff may maintain the decorum of the courtroom, asking people to sit down, to take off your hats, spit out your chewing gum, turn off your cell phones, all of those things the bailiff will say, and the law enforcement person will not say. But the law enforcement will be the one that if there is an outbreak of emotion, let's call it that way, that the judge, that the sheriff or the law enforcement official will take a responsibility and take action. All right, I think we've got everybody in the courtroom all situated. The judges, the clerks, the witness who will come in and then leave, our defense, our prosecutor, our jury, our law enforcement outside is sitting and waiting, and witnesses, and then in the back, our observers.
So Jennifer, can you make? All right, so she's back here at our camera. This would generally be where Alonzo would be, or Danielle, or one of our staff members would be with our families. So that's where.
Yes, that's absolutely right. I would be sitting out there. I would wait with you. And it doesn't necessarily need an attorney. We also have at Maryland Crime Victim Resource Center, victim advocates. And the victim advocates do court accompaniment. That is where a trial is a long and drawn out process. Sometimes you need an attorney present, and sometimes you just, as a victim, you just want somebody there to help you understand what's going on and to get through, give you some strength to get through the process. Let's say that this case is one in which there are going to be a number of evidentiary hearings. That is, hearings that are not in the presence of the jury. They're just motions that the two attorneys have put forth, and the judge has to make a decision about the law. When the judge is making a decision about the law, we don't need the jury, because the jury makes decisions about the facts and about the character of the people giving the evidence. So the judge is now here making a determination about a matter of law, and you decided, I want to see how that happens, what's going on there. You may ask for Maryland Crime Victim Resource Center to send a lawyer to sit in with you so that we can explain to you the different legal machinations, is the word, told not to be using those words, the legal movement and the arguments that each of the sides are making, so that you're able to understand when they say objection, whether you won or lost. And that's what that you can bring an attorney, and the Maryland Crime Victim Resource Center's attorney will be available to assist you. However, there may be a scheduling hearing that's taking place, and the two parties just can't figure out what's a good day to hold the case, what's a good day to hold one particular hearing versus another particular hearing. And so you just want to, but you want to see every aspect of the operations of the courtroom. So we may send an advocate to come and sit with you and to just walk you through the process, to give you, like I said, that confidence to know that you're not alone in this whole process. Please do not hesitate to ask and to let us know what your concerns are, because as an organization that is dedicated to victims of crime, we understand the trauma that even coming to the courtroom can impose on you. And our goal is to make certain that we give you the additional support that you need throughout this whole process. All right, do we have another question or anything? No, okay. Switch to my, you want.
All right, so let's just, so when I chatted with Alonzo yesterday, because we were trying to come up with, and the camera on the other side is really a rough one. So my apologies for it being a little blurry.
That's perfect. That's perfect.
So I just wanted to we really want to bring information and really for the layman's, right? Like, so it's not so complicated, so that everyone can understand. And so one of the conversations that I had, and I actually told Danielle, who's also here with us, who is responsibility. So I think that, and then sometimes in that row, and some Jennifer back there. And probably, what if you don't feel safe? What if you go there and you're, you've got a lot of emotions going on, right? You're anxious.
You want to take this?
What if you don't feel safe? What can people do?
Okay, so I'll repeat her question. The main question was, what do you do when there's hostility between the two families of the prosecutor and the defense? And so Danielle is here. She's going to go ahead and take a bite out of answering that question.
Yeah, I mean, first I would say if you're a victim coming to court, make sure you let us know. Make sure you let the attorney know or your victim advocate know that you're not feeling safe. We will notify the bailiffs who will be in the courtroom. We can notify the bailiffs who are at the main doors, and they can walk you out to your car. They can make sure you sit on a side where you feel safer. So there's definitely options. We want you to feel safe when you come to court. You just need to let us know. When you come for a trial, and if there's two sides where there's tension and it's difficult and it's a hostile environment, most times the bailiffs will have one family stay on a break and the other family go. And the bailiffs will walk one family out to their cars. As they're out, another bailiff will walk the other family. So they try to separate them as much as they can, different waiting areas, just so to eliminate the times that you're nearby. So that's all to help people stay safe and to not cause more issues when you're at the courthouse.
Thank you very much. And that's absolutely right on target. The court experience is going to be new to you, but it is not new to the people who work this every day. The bailiffs are aware when they have a domestic violence case that they're addressing, or a crisis that is involving a family member, and they will do, just as Danielle has mentioned, post people in different areas. They will control the way that the courtroom works, and they will control the way that they let witnesses in and out of the arena. So it's very important that when you get to the courtroom, you actually follow the guidance of your law enforcement and your bailiffs that are there. Quite frankly, there's so many times I see people think that the bailiff is trying to control them in some way when they tell them turn their phone off. But the reason the bailiff doesn't want you to have your phone on is because we don't know if there is a threat to one of the witnesses, and perhaps someone is recording them or taking a picture of them so that they can threaten them outside of the courtroom. The last thing we want to have happen is for a witness or a family member to become a victim because the courtroom that they came in to do their judicial and their civic duty became a threat to them. So listen to what the judge is saying, listen to what your clerks are saying, and to what the officials in the courtroom are doing, and they will help you get through this process. Now, your Maryland Crime Victim Resource Center personnel, you ask yourself, why do we need an attorney for the victim and an advocate for the victim if the state's attorney already has attorneys and they already have advocates, and some counties do have advocates? Why do we need a separate set? And the reason why is because Maryland Crime Victim Resource Center has attorneys and advocates that are dedicated to the victim. We are not in charge of so many cases on a given day that we're unable to provide you, in most cases, with the direct attention that you need and address the concerns that you may have. In contrast, the state's attorney is in charge of cases for the entire county. So one attorney, assistant state's attorney, may have 20, 30 or so cases that they're working. The advocate, which will be fewer advocates than there will be attorneys, will be working for 2 to 3, maybe even 4 different attorneys. And so all of those witnesses, I mean, all of those victims, first of all, as well as the witnesses who may not be victims, but they are a different set of people that your advocate has to be responsible for, are going to fall on that one particular person. And on occasion, you will feel left out. Not intentionally, it's not the goal of the attorneys, it's not the goal of the advocate to disregard you or not answer your question, but you're asking a question about one case and they've got 5 other cases and 2 of them have already started at the same moment you're asking your question. Your case may be over and but their day is still moving forth. And so not out of disrespect, but just out of the management of justice, they're unable to provide you with the additional guidance that you need. On many occasions, we as attorneys with the Maryland Crime Victim Resource Center are able to provide additional assistance that you might not otherwise be able to get. So it's good for that particular purpose. The other side, I'll just be very quick on this one. The other side is sometimes the state's attorney or assistant state's attorney has a different view about what victims' rights means in their particular case. And in order to win the case, they may want to sacrifice a right that a victim has, or maybe a softer term, maybe to skirt the hurt. You have a better way of putting it? Minimize, thank you, minimize, okay. Minimize the interest that the victim has or the way they exercise that victim's interest. And so we're here to do our level best. It was interesting that the state's attorney said, as a prosecutor, I have a judicial responsibility to find justice. Well, he's the prosecutor, but he also has a responsibility that is extended to the defendant. In order to find justice, he may determine that there's not enough information to go forth after that defendant. However, we don't let that prosecutor sit and say, I'm going to be the prosecutor and the defense counsel, because you just need someone that's going to be advocating entirely on your behalf. And that's what we do as attorneys and advocates in the Maryland Crime Victim Resource Center.
All right, so going back to if you feel unsafe, you have certain feelings and need to be escorted or what have you, make sure that if you're working with an advocate, you let them know your feelings, let them know what you need. They will do their best to see if that's a possibility or what have you. I think that it's important to share that information and to a certain point, advocate for yourself by using your voice and letting us know what you need so that we can help. 2 other things popped into my head, and Alonzo, I know you and I talked about it, but we did talk about families being in the courtroom. It could be, when me and Alonzo were talking yesterday about how the courtroom is set up, I was like, is it like when you go to a wedding where if you know the groom, you sit on the groom's side, if you know the bride, you sit on the bride's side? And so that's why he was talking about what side you sit on. And really, where there's space, you can sit. What is the cat saying? If I fit, I sit, or something like that, right? And so that's okay. But what if you had a really big family? These things happen, with some families are very big and everyone wants to show support. Your best friends come in and then your family is, 5, and then your auntie and, everyone wants to show support. And like in this case, this courtroom is relatively small. It's actually pretty small. I haven't been to as many courtrooms as these guys, believe me, but to me, it's small.
It is. You want to jump on that? What would you say?
Yeah, I would say at least here in Calvert, there's a jury trial going on right now. The bigger trials are the upstairs courtroom, and it will hold about 100 people. So our victim's family has had 50 to 60 people here each day, and that's just on one side. But the bailiffs will, trying to squeeze family members in and keep people on a certain side, but it's about 100 people, at least in Calvert County, and I would say probably most bigger courtrooms.
Yeah, I would say the same. I do practice in Prince George's County, Anne Arundel County, and I've done Baltimore City as well as on a more regular basis. And if it is a trial that is going to have a jury, we're going to go to a bigger courtroom. If the jury trial looks like it's going to have a lot of witnesses and it's, or if not witnesses, a lot of family members or community members, then they move to a larger courtroom. Now, there comes a limit where courtrooms are just, they're only so large. Then there will be occasions when we'll do an overflow room. That is, they'll take a courtroom that doesn't have a court case going on at that particular time. And with the new technology, they will pipe in the proceedings on one of the TVs. Can you point to that TV over here? Okay, there you go. It's not.
I'm like camera deficient today.
It's not the largest TV available, but they can turn the sound up, and at least you have the opportunity to see what's going on in the trial. Now, let me just say this. For the immediate family, for the victim who is registered, who has completed the notification or notice of victim
Crime victim
notification form. Thank you. The person who has completed the crime victims notification form, they do get a little bit of preference. And so if the courtroom is full, there is a seat that we have for that particular person, provided they're on time. And understand, this is an aside, if you are late, you will not get a seat. Okay, there is no excuse for coming to court late. You will, if you are the defendant, you may lose your case if they proceed without you. And if you're the witness, you may cause someone to lose their case because the case cannot go forth without you. So do understand that legal proceedings are official proceedings. The judge, the clerks, we already talked about the number of police that will be present, the bailiffs, the courtroom is set up and reserved for your particular legal issue. If you don't show up, you may lose the opportunity. So show up on time. All right. So if you're not,
people be asking, like, if they know that they're going to have a lot of family support, should they be letting people know that so that they can accommodate, or?
Yes, you need to let us know. Communication is the key, but understand that it does not mean that you will get what you want. Right?
And then if they're running late, because you touched on that as well, and I remember, so like if there's not space for you because you're late, then
you may end up sitting outside, or you may end up being sent to an overflow courtroom if that is made available to you. And I will jump to something that kind of brought a lot of this together. During COVID, not only did the small courtrooms get significantly smaller because we had to maintain the distance, but the number of cases that were being heard at any particular time were delayed because sickness and the fact that we were trying to stay safe. During that time, a lot of courtrooms upgraded their technology. Some courtrooms and in different counties, the chief judge for the entire court system gave the authority to do some cases through Zoom. So there are ways to mitigate the overflow, the number of people that are present and need to get into a courtroom, but you just don't know unless you let us know what the problems are, what your concerns are, and then understand that we're going to do our very best to accommodate you. We do telephone hearings for many family law cases. We do some hearings that don't require witnesses. They're just legal debates to be done through Zoom. And we allow for video to be sent to another courtroom to try to accommodate the witnesses and victims. But what's important, this is what I would, if we did nothing else, I just want you to walk away with. Talk to your advocate and talk to your victim, a victim attorney early. You don't have to do it 50 different times in a 3-day time span, but you do need to let them know what your concerns are. You have to let them have some time to try to resolve those concerns, and then you need to follow the guidance that they give you. And my guidance is not being given with the idea that I don't understand the pain and suffering that you're going through and the anxiety that you have, but this given to you with the idea that if you follow that guidance, it may help you get through some of the anxiety that you have, because you'll know that somebody is taking care of those issues, and we're in the best position to move things forward within the courtroom than you may be, just because we've done this a lot more times than you have been. All right.
I felt like that was a loaded information there. And of course, I'm like looking for a sheet of paper because I'm like, let me write something down.
Just go ahead and
so I
ask the
don't
question.
remember to ask it. So you touched on there being Zoom court. So clearly, if it is Zoom court, it's not going to look anything like this, right? Like it's going to be completely different, and that can be a plus and a minus, right? Like there's all those things in communicating with our organization and with whoever. Can our families say that they prefer
Very good
Zoom
question.
court?
I like that question. You want
I
to
mean,
look up in our
clearly,
second?
not everyone can get off work and,
Yeah.
conference.
So
and
what
have you.
we have done, and we've had this problem come up in our organization, where a family has said, I don't agree with having to do this by Zoom. I want to see the judge so that judge can feel my angst.
Feel all the
I
feelings.
want to be present because I want to see that person. And we, as attorneys, will make that argument to the judge, and there will be there's a balancing of responsibilities and authorities. You have the right to be present. Is the defendant going to be in the courtroom at the same time? Because that may help us increase our options. So there are a lot of issues that will play in, but we as Maryland Crime Victim Resource Center, we start with you have the right to be in that courtroom. And unless the court has decided by its order that it's not even having that in-presence hearing, we've been pretty good in getting that taken care of and getting that person present. Not for everybody. Not for everybody, meaning the second cousin who flew in from California, and while that's a very important, may not be able to be present. They may have to sit and listen in on the phone call with the rest of the family, or watch it on Zoom with the rest of the family, as opposed, even though they've made a long trip and we understand that that's. Would you add anything else?
No, I was going to say, at least in Southern Maryland, where I help victims, in Charles County, they do Zoom court and circuit court, not district court, for lesser hearings. I don't know what the
non-violent. They're
like motions hearings, status conferences. All those can be done over Zoom, and you can also come in person. But I realize a lot of our victims like to watch everything, but so some of those things that are on Zoom are way easier for them to watch. So you let us know, hey, I would like to be involved and watch everything. Then we can always give you the Zoom link for some of those motions hearings, status hearings, pre-trial conferences. So you don't have to leave work for very long and go in person. But then when it comes to trial, sentencing, all those things are in person. They don't do a jury trial or that over Zoom.
So some of the more administrative things.
very good. The lawyer. That's right. No.
Okay, that's absolutely great to know as well. I mean, because I think that I've heard that from a lot of our families that I don't deal directly with, victims like these two do, but I mean, what I hear is, taking off work, they want to be, I mean, of course, especially the more serious the crime, the more engaged the families want to be. And it just makes it really challenging depending on your job and how, how your supervisors, how your leave.
What I would like to say, though, what I want to say is that we, as I always keep saying, the Maryland Crime Victim Resource Center, we really do push for you to be present in the courtroom and to at least see what's happening throughout the whole process. And the reason that we think that is important is because if you have an understanding of why a piece of evidence that you know exists was not put forth into the case, or you know why we're having a case today, and then we're not going to have another hearing until 3 weeks, 4 weeks, if we're lucky, down the line, then you can have confidence that you'll, knowing why that took place, it can alleviate you creating someone telling you that the reason why is because the judicial system doesn't care about you, it's all a scam in the first place. But if you've been sitting in the courtroom and you've seen the debate between the two attorneys, that one has a trial that's going to be in the middle of that case, the judge has another major trial that's going to happen 2 weeks after that, and the closest date that they can come up with happens to be a month and a half later, then you can walk away knowing that there was an effort put in place to make sure that the speedy trial was taking place. It doesn't always work out that way. It doesn't always work out that we can get things done quickly, or that what I think was a good answer is what the defense thinks is a good answer, or you think is a good answer for the particular process. But to understand that there is a process, to understand that people are really taking into consideration your interests and the interest of justice in their efforts, it's an important element of the judicial process. And I think it's one of the reasons why Maryland was able to get the statute changed and the various statutes passed on victims' rights, and the amendment to the Constitution to make sure that you are treated with dignity and respect when you come into the legal system by the legal system. It's not treated with dignity and respect by the defendant. We're not worried about the defendant's treatment of victims. We're worried about the state prosecutor and the judge, the law enforcement officers, how they treated you with dignity and respect, because they represent the judicial system.
Thanks for that. And so I guess one thing that also pops into my head is when you were talking about the bailiff saying to spit out your gun or put your phone away. So let's talk about like attire, right? Like, you know, we're coming into this courtroom and, you know, they always say, just wear what, like, I'm not a big proponent of that. Like, you know, the mother of 2 teenage boys who want to wear hoodies when it's 110 degrees outside. Listen, you know, we're going to try to make things right, you know. Thoughts and comments on that, on even the family that's sitting in the background, right? Like,
you have this trial going on with all those people.
I mean, I think it's more important when you're in front of a jury trial, because the jury is, they're people, they're watching you. So you need to be mindful of your etiquette in the courtroom. What you're wearing, you don't have to dress in a suit, but just a nice shirt, jeans, just looking like it's a serious matter. You're there because you obviously care about what the outcome of the trial, but you're there, you're respectful, you're not talking, you're not laughing, you're being respectful when the judge gets down and off the bench. Those things, the jury is watching everything. So jury trials can be long, and you can have witnesses on the stands all day long. So they're constantly looking and seeing what everybody else and what everybody else is doing to react to what is being said. So just trying to maintain just a calm presence and do nothing to distract a jury is probably the advice that I would give our client's family.
And I don't think I can add much more to that, particularly that phrase, do nothing to distract the jury. Your personal style, I'm a gardener. I love overalls, my straw hat, and a pair of flip-flops when I go out into the yard. I don't come into the courtroom when wearing that attire, because it would distract, even if I make the same arguments I'd make in my nice suit. I think it's a nice suit. If I made the same arguments in my suit that I made in my overalls, the judge and everybody else present is going to be distracted by my attire, and therefore they're going to draw conclusions about me regardless of what I say. Ironically, I do a lot of my legal analysis while I'm in the garden, while I'm dirty and with, like, so with my overalls on. And then I get dressed up and I come to the courtroom and give those same arguments. I'm the same person dressed in something different, but people's stereotypes, people's just their opinions about what they're expecting are different. So if you as a victim come in your best, I don't know, gang T-shirt. I'm making that up. Major club. I'll say bike clubs, brothers in the bike club. Come into your best bike club gear to testify that this is a great family. The stereotype of a bike club might be negative to one or two people sitting on that jury, and they will draw. And if they rule against you, then you've messed up that trial for that particular person. Remember that it's not about you, it is about that particular case. And if you can dissuade yourself from showing your personal style and your great selection of whatever the gear is that you particularly like, for the benefit of the decorum of the courtroom, then that's going to be beneficial to everybody involved. And I will say, we mentioned earlier, I told you that the judge addresses the law. So there are statute 1 and 3 and 4, and the prosecutor says 4 is important. The defense says 4 is not. The judge is the one that decides if that's important or not. The jury is making a determination of the character of the witnesses, the importance of what they say as to whether they can be believed. And if your attire gives them the impression that you're an untrustworthy person, then even though you're telling the truth, it's going to be a problem. Granted, I'm gonna state it just so that there's not a perception that we didn't think about it. There's discrimination about what a person wears. So the moment you say hoodie or I say gang wear or things like that, you come up with these views of this drug dealer, this, that, and the other, and it's just the attire of the youth today or of anybody in their particular matter. That's all right, and then there are going to be occasions where you have to wear the proper attire for the game. As we used to say, you don't wear your Timberlands to play basketball because you need to have your Air Jordans on. So you don't wear your Air Jordans when you come to courtroom because that's not what you're here for. Although, quite frankly, you can't wear your Air Jordans.
So you mean to be supportive, but you might not be so supportive. You might actually be detrimental.
You may become detrimental to the case.
And I do like that Danielle said jeans, because I mean, I think that, like, when I think of jeans in a courtroom, I think of, like, when you had to pay, I don't know, whatever, pay $5 to wear jeans on Friday or whatever, and you had jeans, but you had blazer and shoes on or something like that. So, you don't have to go out and go shopping, but
I do want to bring up one more attire topic. I've seen a lot of homicide trials. Families have shirts made up with the victim's picture or staying on there, which is excellent. And we see them at our walks, we see them at events. It's a great way to honor your loved one. However, they're not appropriate for court. We've had victims' families come in for the jury trial and they're wearing them. In my experience, judges will make them turn them inside out, make them put something over top because they don't want that to be distracting to a jury. So if you do have family shirts, we ask that it's not a good idea to wear them for the jury trial because it's more than likely the judge is going to ask you to change or put them inside out anyway. I don't know if.
Nope, that's great. That's absolutely great. It goes to that distracting the jury. And if you are campaigning from the witness, the observatory area for a particular person, the defense can use that and say that it was an unfair jury selection, that's jury deliberation, because they were dissuaded by all the T-shirts and the fanfare that was going on behalf of the victim. And now you've given the defense an opportunity to get your answer. If you won, you give them an opportunity to have the case overturned.
Great addition with that, Danielle. Thank you so much. Because yes, we do see them. They're heartfelt. But I think that in this instance, I think the support and people coming into the courtroom, I think is plenty, and it really shows a lot So anywho, we've got about 3 minutes left. So just wanted to wrap up. Were there any last quick things that you guys could think of?
The only thing I would say in closing is a repeat of what I said earlier, and that is talk to your attorney, talk to us early. Don't wait till the day of the trial to call Maryland Crime Victims Resource Center and say, hey, I've got a major issue that I need to. Of course, if that happens, do it, but get to us early. It's better to have an opportunity to figure out what we can do than to have to do the shoot from the hip.
I think that's excellent. And I know I've spent a lot of time talking about jury trials, but any crime, we're in district court a lot for victims, circuit court. Any way we can help, we're here to help the community and the victims that we serve in our communities.
Thank you so much.
Do you want to go ahead and give them our email, telephone number, and all the like?
So thank you so much for joining us. For you guys at home, if you're watching this, not live and through the recording, please make sure that you reach out to us. You can message us here on Facebook, on any other type of social media. We are available. We, like Danielle said, we do all types of crime. It's not just homicides. It's not just domestic violence. We do everything. And it is for people of all income brackets, so you don't need to qualify financially. We are available to you throughout Maryland, so please let us know. If you have questions, go ahead and drop them in the chat. This will be uploaded onto both Facebook and YouTube, so make sure that you grab it there and share it with all of those who you may think are could benefit from it, because you never really know who you're helping when you share our videos. And that's all I have. Alonzo, was there something that you wanted me to pop in there?
I was going to do a layout of the courtroom, but I think they got a good sense of it.
Okay.
Looks
so
like our
that's it, and
jury
we
is.
will see you next time.
Looks
All
like
right.
our jury trial is coming through, so we're going to see you later. Bye.